So welcome, everybody. My name is Kelly Mitchell, and I'm the... Uh-oh, did I do that? Yeah. I'm the executive director and not the technology master of the Robina Institute. With me today, I've got Bennett Wright, who's the executive director of the Alabama Sentencing Commission, and Scott Schultz, who is the executive director of the Kansas Sentencing Commission. And at one point, all three of us served together on the executive committee of the National Association of Sentencing Commissions, and Bennett is the president of that organization right now. So we have a lot of experience in the room, sentencing guidelines and sentencing commission wise. And the point today is to sort of go through and talk about how commissions and guidelines work in different jurisdictions, and of course to tell you how Minnesota is the best. But you know, there's a couple of things we could still learn from other jurisdictions. So here's the agenda for today. We're going to talk about what are sentencing commissions, what do they do, what are guidelines and how do they work, and what makes Minnesota a leader, and where could we learn from other systems. So this is just a slide that demonstrates all the sentencing commissions that currently exist in the country. You'll see that the ones that are dark blue are sentencing commissions that have been tasked with developing sentencing guidelines, and the ones that are light blue are sentencing commissions that have broader mandates. They were not tasked with developing guidelines, but they generally work in the criminal justice system. And I'm really excited to report that Nevada just created a sentencing commission, so I haven't added them to the map yet, but we will. They'll be in the dark blue zone because they have been created with the purpose of developing guidelines, and we'll see if they get there. So there's really, as I mentioned, two main types of sentencing commissions. Some are established for the purpose of creating sentencing guidelines. So that means that the state has really taken this view that sentencing guidelines are the type of policy that they want to enact to have guided discretion regarding sentencing within their state. And then in other states, they're really looking for a broader sort of focus, a broader mandate, a broader purpose. So the commissions in those states, Connecticut might be an example of one of those, are formed not only to look at, not just to look at sentencing policies, but to look at the criminal justice system on a broader scale. They might specifically study bigger issues like what do we do with sex offenders in the state? How do we handle reentry? So they are tasked with some of those larger issues, and they tend to provide advice to the legislature on those issues. And some commissions do both. These are, if you sort of look across all of the enabling statutes for sentencing commissions, these are a few of the sort of frequent flyer purposes that might be listed within those statutes. So some are formed to sort of review and recommend changes to the criminal code, criminal procedures, sentencing policies or practices. As I mentioned, some are formed to develop guidelines. Often, commissions are tasked with collecting and analyzing data about sentencing practices. And this is a really important purpose because it allows the commission to be that sort of source of information, of expertise. If they collect data over time, they can see what's really happening, and we can learn how policies are being implemented within the state and if they're having the intended effects. Many commissions forecast correctional populations based on those practices, and collecting that data gives them the ability to do that. Many develop fiscal or racial impacts and analyses of proposed legislation or policy changes. They might conduct training and education, and then the catch-all that a lot of commissions have in their statute is serve as a clearinghouse for collection, preparation, and dissemination of sentencing research and information. So basically, be the place where that information exists. I'll say that in Minnesota, I should have mentioned that I formerly was the executive director of the Minnesota Sentencing Commission, so I'm going to take that role here and draw from that experience to talk about how Minnesota works. But Minnesota has generally stayed in the lane of working with the sentencing guidelines. We were the first commission in the nation to create a statewide sentencing guidelines, and we were formed for that purpose. So the development and maintenance of sentencing guidelines has been the primary purpose of the Minnesota Sentencing Commission for the majority of its life. And from time to time, they've been asked by the legislature to look into specific issues, and they've done so. But usually their work really revolves around what is going on in sentencing and what recommendations do we need to make to ensure that the sentencing policies are being carried out the way that the legislature intended that they should be. So that's the lane that our commission tends to stay in. What about Alabama and Kansas?
Well, in Kansas, I knocked over my purse, sorry. In Kansas, and I just at the outset, thank you so much for allowing us to be a part of this particular conference. We have, as I think we get into it, I'll be able to express my appreciation even more for Robina and the things that they've actually been able to provide as far as support in Kansas. But our commission in Kansas is a 17-member commission. We have a full cross-section of criminal justice professionals, from appellate judges to district court judges to attorney general designee. We have defense attorneys, other prosecutors, probation officers, as well as legislative leaders from the House and the Senate. And so we try, and I've been with the commission for about 6 years. I'm a former prosecutor and did defense work as well. But what I can tell you is I want to be a one-stop shop for our stakeholders as far as data is concerned. And that's really what we do in Kansas, is provide data to our stakeholders, whether that be the governor's office, the legislature. So when they have a question as it relates to criminal justice, I want them coming to us. Because we are a freestanding agency. We're not beholden to our Department of Corrections or any other agency. And so that provides a level of objectivity for us to be able to do the legislative impacts like Kelly was talking about. We also do prison bed space population projections for our Department of Corrections. We also do research requests from all over the country when people are wanting our data. We have our Sentencing Commission was instituted in 1989, and then the guidelines themselves went into effect in 1993. So we're a little bit after Minnesota, but we delve a little bit farther into, and again, like I said, we want to bring value to the criminal justice system in Kansas, and in doing that, we've kind of broadened our scope outside the realm of just sentencing. And when it comes to sentencing reform in Kansas, again, we want the commission to be the leader in doing that. And so that if somebody is looking for, we do have the defense bar that has a part-time lobbying at the State House, but I kind of turn into a lobbyist when it comes time for the session to start up, because we actually are required by statute, if we're running pretty close to capacity as far as our prison population, we are tasked to actually give recommendations to the governor and the legislature as to how we can stave that particular capacity issue. And so as a result of that, that allows us great latitude to be able to expand the reach just from sentencing, and that even includes raising and lowering severity levels of our crimes. Looking at, we were just asked to do proportionality study for this next year as well. And for some of you that have already experienced justice reinvestment, we were actually the tip of the spear that actually drove that particular initiative as well. So again, that is something that that we want to be a very active part. And it makes sense. Our membership constitutes the cross-section of the criminal justice community. So why shouldn't we be having those discussions and conversations? I usually tell people that I like for our members to bring with them their own agendas, because we vet a lot of that stuff in our meetings then that we have on a monthly basis, so that we can have good policy coming out of that. And we'll talk about the legislature hopefully here later on. But it bodes very well once we take those policy discussions and proposals to the legislature.
The experience in Alabama is very much the same as it is in Kansas, except kind of echoing something what Mr. Foreman said this morning. Alabama, in a lot of respects, is all of the above state. In kind of addition to what Scott says, I serve on the Criminal Code Revision Committee, on a Collateral Consequences Committee, and at the commission we also train all of the judges every year. We train all the prosecutors, and we train all of the defense bar as well. So it's actually a lot of work. The one thing I will say from the outset that you don't want to model after Alabama is we have a staff of 2. We have a 21-member body sentencing commission, but we only have a 2-member staff. So it's very important for us every year to prioritize all of the events that we do, particularly when we have a massive event such as Justice Reinvestment Initiative. Kind of like Scott said, when they led the effort, we also led the effort in terms of training, sentencing, implementation, et cetera. So it's great to have all that credibility and respect within the state, but it also does pose problems when it comes down to managing the workload as well.
Yeah, that's actually a really good point that you bring up. I mean, the size of the staff and what the staff can do is really critical to what the commission can do. Nate, are you up to 6 or 7 now?
6 including.
6 staff. So our staff size is 6. And then, Scott, how big is the staff at your commission?
13. We have 13. I have 3 staff that, in addition to some of the things I described to you, we have a staff of 3 that actually runs a substance abuse treatment program. That's a statewide program called the Senate Bill 123 program, and we dole out about $6.5 million a year to on possession-only offenders that get caught up in the system. We have state-paid substance abuse treatment if they fall into certain criteria. So I have 3 extra folks that are working on that to pay invoices and to run that program.
So Scott, you got into this a little bit earlier, but so almost every commission that exists is tasked with helping to manage correctional resources, but really how that plays out within each state varies by what the commission can do. So I mentioned that our state is one that's been collecting data since the beginning. I mean, it's really a beautiful thing that you can go back to 1981 and see what the sentencing patterns have been over that time. There is a treasure trove of data here in Minnesota. But what it also lets us do is actually predict what the impact will be of any new legislation, of any change in legislation. We can actually run those numbers because we have a good idea of what judges are already doing, so we can predict what they'll probably do under that new law or under that changed law. And then the commission here also works with the Department of Corrections to project the prison capacity, because we can tell from analyzing that data how many are going to go to prison, how many are likely to go to probation. So it's a really, really important function for the commission. And then Scott, you mentioned this a teeny bit, but you go a little bit further. You have a responsibility to provide the legislature with solutions when you're getting up to 90% capacity or something like that. So can you tell us more about that?
Sure, we do. We have several statutory duties that are, and one of those is that particular requirement. So what we normally do is we'll have a 2-day workshop that will bring in the commission members for that time period and go over an agenda. I have a legislative committee that of commission members that we get together, kind of put together a loosely held type of agenda that if there were some hot issues that were going on, if there's some case law that's come down that the legislature has that needs to be acted on the next session, those are the things that we're going to talk about. And if there are certain issues that certain commission members, of course, are interested in. In particular, we're looking at more into offender registration than some of the issues as far as it being ineffective. In terms, we're one of the 17 states that actually still does comply with the Adam Walsh Act, and so. We even go further in registering drug offenders and violent offenders, in addition to sex offenders. So, if you can imagine a third of your felony population having to register, that would be Kansas. But we get together and do a lot of different things, and it's very good to bring in folks that are very learned with expertise, and they're very much willing because they know that, I have the Secretary of Corrections, I have the chairman of the parole board, I have all those folks on our commission, and they're the movers and shakers that can, a lot of times our legislators are chairs of their respective judicial and corrections committees, and so that pulls a lot of weight, and so this is a good forum for to look at those reforms.
Do you play a role in that too?
One of our general statutory provisions is on a yearly basis we're required to make recommendations to the governor and to the legislature about how to make the criminal justice system more fair, effective, and efficient. So that is a pretty big mandate, and just like Scott said, our commission members are chairmen of their respective committees in the legislature, and so that really holds a lot of the weight. I think we do a lot of work actually more in our subcommittee structure rather than we do in our full committee structure. The commission body itself usually has members of the victim community, law enforcement community, and in our subcommittee structure, we have committees that are completely comprised of nothing but judges, lawyers, and prosecutors, and those are usually the subcommittees that bring their vetted ideas up to the full commission body, and if it's been vetted by those subcommittees actually fairly well, it stands a much better chance of passage actually by the entire commission body itself.
All right. Well, we've brought up a little bit about what these commissions look like, so let me show you a few slides about that. So this is a comparison of the size of sentencing commissions, and the three that are represented in front of you today are in red, and the rest of them are in gold. So Minnesota's showing up on the small end there with 11 members. Kansas is at 17, and Alabama's at 21. In terms of who's on the commissions, just about every commission has judges, defense attorneys, prosecutors, and representatives from the Department of Corrections. But then when you start to move across the slide over towards our direction, you get more variation in the types of members that might be on those commissions, with some having legislators and some others not, some having police or law enforcement representatives and others not. Scholars and experts are down here way at the smaller end. So there's a couple of different types there. And then here's the three commissions represented in front of you. And you can see a few differences there. Alabama and Kansas both have legislators on their commissions, but the Minnesota Commission doesn't. On the other hand, Kansas and Minnesota both have victims or advocate representatives, public members, and Alabama doesn't. You'll see that Alabama and Kansas both have parole represented, but that's because they both have parole, and we're a supervised release state, so we don't have that function. So that's really covered by the Department of Corrections representative, because the Department of Corrections handles any post-prison supervision. So that's not really, we're not missing anything there. And then community supervision is represented in Minnesota and Kansas, but doesn't appear to be on the Alabama board. So, I'll make a comment about size first. With our commission being a lean, mean 11 members, one advantage is you can discuss a lot in a group that size. You have the ability to get issues out there on the table, and everyone has the opportunity to say what they want to say. But because it's small, if someone doesn't show up, that can really tip the balance, and sometimes you might have to rediscuss that issue when they do show up the next time. So we have those are the pros and cons. Sometimes the commission has been occasionally criticized for not having considered everybody's viewpoints, but maybe that's a function of its size and not everybody being on it. But honestly, I think that criticism is probably lobbied at every public group, no matter who's on it. So I'll take that one with a little grain of salt. And then in terms of membership, let me turn it over to the two of you. The first question I would have for you is bigger better? And then the second question I would have, I'd really like to hear from both of you, since you both have legislators on your commissions. I'd really like to hear how that works out, and what are the pros and cons of having legislators on your commission?
Just a quick point of clarification. We actually do have 2 victims advocates now. That changed. So in Alabama,
it's new.
A couple of years, but it's fairly new. I would advocate for a much smaller commission than in fact we have. I joke around and say I'm all for a 3-member sentencing commission. I think particularly once you move past a lot of what people consider the easy issues, the more problematic or complex the issue is, you reach a situation where you just prevent yourself from a unanimous response, and you end up in this bickering back and forth. If it's a 11-5 vote, the 5 that lost say, well, we didn't vote for it. And so even though publicly you can say the commission voted for it, you can have 5 vocal opponents saying, yeah, and that was actually over my dead body. And so with a wider range of viewpoints, I think the more complex the issue becomes, in my experience, the less beneficial it really is to actually have a larger commission. In terms of having the legislators on there, I think it's personally been very beneficial. I think it's allowed us to prioritize what we do. If you have two influential members of the legislature that can tell you, hey, Scott, you really may think that's the best idea ever, we're not going to touch it, then I can reallocate my time and my resources. Or if they say that's worth a try, or I'm willing to jump on board, then you can much better focus your actually limited staff's ability. So I think it's a huge plus to have legislators, as long as they're willing to have an open line of communication with you.
Yeah, I would agree on the legislative aspect. It certainly is. You have some continuity of or continuity of issues with those legislators, and so it's not just when you introduce the bill at the beginning, first week of the session. They have been well invested in the process. They know the issue, and then they can explain it to their fellow committee people. And so that has reaped major benefits for us. As far as we usually take anywhere from 6 to 9 bills every session, and so being able to understand what's going on makes it very convenient. Now, what I would say again, caution would be just as Bennett indicated. If you have a legislator that may not be so supportive of that, you may get into a hypothetical situation where the bill is on the floor and you have a commission member that specifically gets up and says, I don't support this bill and I'm on the commission. That's a hypothetical, of course. So those are some potential pitfalls, but the familiarity with the situation certainly, I think, outweighs anything else, because you're not operating in a vacuum then, and Kansas is required. We are not in a situation where we can just pass those things like Minnesota can, and then deal with a potential override, we have to put all of our policies that we change through the legislature for approval. So that in itself makes it almost mandatory for that. What I would actually, I am interested. We do not have an academic on the commission, and I think that would be very helpful for us. We end up bringing in academics anyway to talk with the commission, and so it certainly would be. We do have several Regents institutions that do work on criminal justice, and I think that probably would be something that would be, that may be different than a different result, but I think it's been helpful, and it also helps bridge the research versus practical application bridge. It helps bridge that gap that I think sometimes that researchers are frustrated with, and then practitioners are also frustrated with as well, as bringing that research that y'all have done into perspective, and how can we use that in practice.
Do you want to comment on that, since you have that person on your commission?
Sure. No, I would say just exactly what Scott says. It's always helpful to have someone other than just commission staff who has a background in data, since that's such a central focus of a lot of the work we do. It's nice to have someone else that's a member that can articulate that to other members, and usually that's always a voice of support, because that's someone that really trusts in the work that you put into the data. So that having an academic expert on the commission is generally a huge source of support for us.
All right. Well, let's for the benefit of those who may not know what sentencing guidelines are, let's talk about what they are. So they're a set of standards that are put in place to establish rational and consistent sentencing practices, and I'm sure that says absolutely nothing to you. So, but I'll show you as an example in just a minute. But basically, we're using parameters about the offense that was committed and about the offender, usually their criminal history, to sort of give assistance to the judge as to what an appropriate sentence might be in that particular case. These are the primary purposes that tend to be stated behind the scenes for why we have sentencing guidelines, and these all apply to Minnesota to secure public safety, foster proportionality meaning that an offender who commits the same crime and has the same criminal record will receive the same sentence as another similarly situated offender. And that as crimes increase in severity and records increase, so will the sentence. So it's proportionality in both of those directions. The goal is to reduce disparity, and that means not just racial disparity, but geographic disparity, and just unaccounted for differences in sentencing. That's the goal. To manage correctional capacity, achieve certainty. It's really important to understand that sentencing guidelines are created for the typical case. So you want to think about, what's the average robbery look like? What does the average drug possession case look like? That's the case that guidelines are attempting to sentence. And then most guidelines build in departure rules that give the judge the ability to impose a more severe or less severe sentence if they're dealing with the atypical case, the case that's different than average, the case that's more serious than average or less serious, the offender who's different than the typical offender who commits that crime. I'll get into a little bit more detail about how the guidelines work, but the first thing I actually wanted to go back to is the point that Scott raised about how guidelines are developed and approved. So there's actually some variation across the different systems as to where the guidelines live and what authority the commissions have to enact them. So in some systems, the guidelines live in administrative rules, or they are their own set of rules. In some systems, the guidelines actually reside in statute. They are statutory creatures. So that somewhat dictates how much authority the commission has to put those guidelines out. So Minnesota is an override state. Our guidelines are a freestanding set of sentencing rules. And the commission can change them, but if the changes that the commission makes actually affect the sentence, then those changes need to be put in front of the legislature at the next session. The legislature has that session to either do nothing and allow the guidelines to go into effect, or to pass a bill to either stop the changes from going into effect, or to direct the commission to do something else with them, maybe tweak them a little bit. Maybe they would, sometimes the legislature actually allows the changes to go into effect, but makes a small change in how they're going to go into effect. So that's an override. Other states require legislative approval, meaning every change to the guidelines has to be put in front of the legislature and has to be enacted into law by the legislature. And then there's a couple of other methods here, sometimes involving administrative rules processes. So if you could both tell us a little bit about how these changes work in your state. I think, Bennett, you always have the menu. You always have a lot of choice.
We do. We actually have both. For our nonviolent offenses, if we make changes that are recommended in our annual report, like Kelly said, those become law unless the legislature rejects them specifically. But for violent offenses, if we make changes to sentences for violent offenses, we have to submit that through the typical legislative process via introduced bill, and then the legislature would actually have to approve that bill.
I think the main historical background on our guidelines, when they were passed in '93, I think it was by a very small vote. And as a result of that, the legislature wanted to make sure that they controlled the way that policy went, and so that's why we had mandatory. We have a mandatory guidelines, but we also then have to run everything through the legislature.
So I should have mentioned that I actually think that the override system that we have in Minnesota is a good thing because it insulates the Sentencing Commission from the legislature. If the legislature has to act in order to stop the change from going through, it allows the commission to do its work without having to worry about trying to lobby the legislature for those changes. It's a different relationship than legislative approval. And I don't know if any of you had any comments on that.
I think that's a great idea because it certainly is a lot easier for, in terms of, well, I would think it would be a lot easier for the commission to act, and then inaction basically is approval, because there's a lot of snafus obviously that and special interests that creep in after that bill is actually introduced.
I would agree. Coming from a southern, very tough on crime state, it gives the politicians the ability to say that they didn't vote on it either. So it really gives them an out where if something backfires, it's not on their voting record. And so coming from a state such as I do, that's definitely something that they all notice and appreciate. And they also know that they are not going to continue to vote for policies that are widely seen as soft on crime year in and year out. So that gives us the ability at the commission level to make annual changes without the interference of the legislature for purely political reasons.
Yeah, and I should also have mentioned, I keep forgetting stuff. Even though the commission acts independently, they always have a public hearing, and nothing is approved before that public hearing takes place, and the commission has the opportunity to receive public comment and consider that fully. So it's not like they're acting out in a vacuum. All right, so more about what the guidelines are. There's two primary determinants, criminal history and the severity of the offense. And most systems arrange these attributes on a grid. Some use a worksheet. there's a couple of decisions that the guidelines generally help the court with. One is this an offense for which the person should receive prison or a community sanction? So that's the in-out decision. And then the second one is, if it ends up being prison, how long should that prison sentence be? And then the guidelines really vary in how much more information they might provide to the judge. So I'm going to show you two examples of grids that demonstrate those differences. This is Minnesota's grid. And the vertical axis on the left there, going from 1 to 11, that's the offense severity score. So that's where we rank each offense in relation to each other, and with 1 being the least serious and 11 being the most serious. Across the top, that's the criminal history score, and I'll tell you more about what goes into that score later. But as you go from 0 to 6, you have a more serious record. The cells that are shaded indicate that this should be a probation sentence, and the cells that are white indicate this should be a prison sentence, and then the length of the prison sentence is in there. In contrast, this colorful grid comes from Oregon, and there's even more information on this grid. So the yellow zone here is prison, and the other colors are community sanctions. So they show that in-out decision. But they also show down in the pink and blue zones, they show jail days, which we don't show jail sanctions on our grid. If the person's getting probation, they often also receive a short jail term. We don't show how long that should be. There's a column that shows the probation term, so the Oregon guidelines actually set how long probation should be. There's a limit on how far the court can depart from the sentence that's in each cell. And then there's also periods of post-prison supervision that are assigned to each of these levels on their grid. So there's a lot of information. I mean, you can really choose to amp it up or keep it simple. Minnesota has tended to go with keep it simple because that is easier to administer, easier all the way around. Bennett, your jurisdiction doesn't use a grid at all. You use a worksheet. So can you tell us a little bit about what that is and why you went down that road?
Correct. Alabama, we use a worksheet, which a worksheet can be turned into a grid can be turned into a worksheet, vice versa. Real simple reason, when Alabama was exploring sentencing guidelines, some influential stakeholders said they did not want to use bingo sentencing. And this is what's referred to as bingo sentencing in actually the state of Alabama. So we actually used a worksheet. I think it was the correct decision in a way, in that on our worksheet we have individually articulated factors. So we take into account the offense at conviction. We also take into account previous criminal history. And then we also take into account a couple of other factors. That was fairly intentional, and we can actually talk about that later. Traditionally, those were the only two factors that went into Alabama sentencing prior to the guidelines. The only two factors were what you were being convicted of and what your felony criminal history was. And when we enacted the guidelines, we intentionally required the courts to actually consider more information than just those two factors. And so we purposely went for a worksheet design rather than a grid design, even though we could turn ours into a grid.
And Scott, Kansas went for the grid, but multiple grids. So tell us a little bit about that.
If you can recall, back in the late 80s, early 90s, we were in the war on drugs. Nancy Reagan was telling us, just say no. And so part of what the legislature wanted to do in Kansas was to be tough on drugs. And so we have a non-drug grid and a drug grid. And so those are separated. The drug offenses are significantly higher in the number. Keep in mind, these are number of months. Actually, I think some of these are days, but on Oregon's. But ours are represented in months. And so that was a major consideration. Over the years, there has been discussion about putting them back into, merging them into one grid. And then the question, of course, becomes, where do you put all of those drug offenses then on the grids? What we found is that there are, in some cases, they are self-regulating. Prosecutors and defense counsel are self-regulating, and some of those items, even in an Oregon context, for example, if you were at an I classification, they're actually to the right of that as far as an average of what the number of months. So they're actually regulating outside, and we'll probably talk about that in a little bit. But we have two grids, and so depending on if you have a drug offense, you're going to use the drug grid, and they're fairly similar to what Minnesota has.
All right. So there's just too much to talk about, so we're going to move on a little bit. So just to recap, the offense severity dimension is where you take all the crimes and break them, rank them against each other. Most grids have about 10 or 15 severity levels, and I should mention, if you're at all familiar with the federal system, I should have said at the beginning, just put that aside because state systems are very different. And one of the differences being most state systems only have about 10 to 15 severity levels on their grid, and the feds have about 49, I think, or something like that. So it's very, the federal system is much more prescriptive, and there's a lot more calculations that go into it. There's a little more room to move on state grids. The criminal history dimension is not, it's not, you don't just take the prior offenses and count them up and make that your score. There's actually a lot that goes into that. We actually have our criminal history source book on one of the tables outside. So if you want excruciating detail, please pick one of those up because there's a lot of really interesting information in there. But mostly, almost every guideline system includes prior felonies, prior misdemeanors or gross misdemeanors, and prior juvenile adjudications, and then there can be other things that are counted in there, although this other category is where states are starting to shave off other things as they're learning that they maybe were not as helpful to contributing to the score as they once thought they were. The criminal history can be put set up in two different ways. One is point-based, like we had on the Minnesota grid, where you just march across 0, 1, 2, 3. So giving all of these offenses different weights, you add them up, that's your score. The other is categorical, and that's where you set up these different categories. This is Kansas's categories on their main grid, not the drug grid, so you set it up here, and you really are sort of putting a person in a criminal history category based on the number and types of priors. I had a little thing here that I'm not going to do right now. And there's typically a different weighting, as I mentioned, so that these things are added in a little differently. So let's spend a little bit of time talking a little bit about misdemeanors and juvenile offenses. So the weighting for misdemeanors in Minnesota, it takes 4 misdemeanors to equal 1 point. So, and there's a cap on the number of misdemeanors that can contribute to the score. So the goal here is to not allow these low-level crimes to contribute too much to the criminal history score. We have a similar policy with juvenile. The juvenile, it takes 2 juvenile offenses to equal 1 point, and there is usually a cap of 1 point, although in some cases you can go higher than that. So what Minnesota has tried to do is look at these low-level offenses and offenses that were committed when the person was very young and count them, but not count them as much as other offenses. Can the two of you talk a little bit about how these work in your systems?
We have, as you can, if you want to go back just a slide or so, right here, we're at the end on H and I, we do count adult misdemeanors. We don't there are certain misdemeanors that we don't count, lower level misdemeanors, so like minor in possession, those type of things will not get counted as they have to be upper level misdemeanors. We have A, B, C, and unclassified the A's and the B's actually will get counted. So in the juvenile context, do you want to talk about the decay stuff? Yeah. In the juvenile context, we go further on this, and this is where I'd like to give a huge shout out to Robina. Part of their resource book that they did put out has reaped benefits for us in spades as far as looking specifically at how we handle juvenile decay. Now, we had a couple of years ago, we had on the books that some juvenile adjudications, or convictions as some people call them, decay by age 25. And I think that sometimes relates to our frontal low brain development, apparently. But that was what was on the books at the time. And so we did have a decay provision that had been used for several years. One of the things that was introduced as far as Robina was concerned was a gap provision. And this is one which we actually pushed through 2 years in a row. Last year it was actually passed, and so lower level felonies will actually not be counted if there's a 5-year time period between adjudication and the current offense. And so you're incentivizing that offender so that, why do we use 5 years? Because going out too much farther than that was not going to be very beneficial as far as, so if you have a juvenile that's committed, a string of burglaries while they were 12, and now they're up again, they potentially could be looking at quite a large sentence as an adult. And so this actually allows for those to actually drop off if it's been, so time, again, is taken into consideration as far as the decay is concerned. We believe that's going to be very beneficial, and it definitely represents those things as far as how much do we actually count when it comes to juveniles. Some states, I think it's North Carolina, doesn't even count juvenile adjudications when they're figuring criminal history.
Bennett, I want to actually ask you just to respond to the juvenile point, because so you've got, for your worksheets, you use one worksheet to determine that in-out decision and then another to determine the length if they go into prison, right?
Correct.
But you only use the juvenile adjudications for the in-out. Why?
Correct.
Do you know why that is?
Sure. When Alabama's worksheets were created, they were based on historical sentencing data. And it turns out that the use of juvenile adjudications and youthful offender adjudications was only statistically significant for the in-out decision and really not the sentence length decision. I think I just want to, for anyone that gets bored and looks at Alabama's sentencing guidelines, we actually don't have any decay provisions. So if you commit a misdemeanor or a juvenile adjudication 50 years ago, it's going to be counted against you 50 years from now. But what we did at the commission, we did the best we could to ameliorate the effect of someone's criminal history. And I'll just use a quick anecdotal example. 10 years ago, if someone sold $5 worth of drugs in the city of Birmingham, the minimum sentence they could get is 12 years. You had to get a minimum of a 2-year sentence. And then Alabama had 2 5-year mandatory sentencing enhancements for selling within 3 miles of a school. I said 3 miles. And 3 miles of a housing project. You can't sell drugs anywhere in the city of Birmingham and not be within 3 miles of a school, and it's tough not to be within 3 miles of a housing project. So when we did the guidelines, regardless of someone's criminal history, someone can have 10 felonies. They can have 5 juvenile adjudications. You cannot get a 12-year sentence on the guidelines. The maximum sentence someone that distributes drugs now can get is 11 years. So the maximum sentence you can get under the guidelines with maximum criminal history is lower than what the minimum sentence used to be with no criminal history. So that's just an example of something that actually can be done with the guidelines. So even though we do count everything, they count to a degree that doesn't rise to what existing law used to be. And politically, that's one of the ways that we had to handle it. The legislature was not going to repeal. They weren't going to repeal all these laws. So rather than repeal, we put in laws in place that trumped the old existing laws. So politically, the legislature didn't have to repeal anything.
You make a really thank you for bringing up the topic of decay. I'm gonna end it here. We actually have more information we could talk about, but I'll quickly tell you what Minnesota has for decay, and then I want to open it up for any questions that you may have on what we've covered here so far. So decay is a policy where a prior conviction eventually drops off the person's record, and this is built into some guideline systems, but not all. Neither of the systems here has decay except for the juvenile point in Kansas. In Minnesota, the felony will drop off 15 years after discharge from that sentence, and lower level crimes will drop off 10 years after discharge from that sentence. The only odd outcome we have with that is that if we look at the average prison terms versus the average probation terms for any given crime, sometimes we have this weird effect where the probation, because we have very lengthy probation terms in Minnesota, a probation sentence could actually stay on your record a lot longer than a prison sentence. That's kind of a perverse result of the way that our system works, and that's because it depends when the clock starts. We've set it at discharge from sentence. Some jurisdictions have set it back at the time of sentencing. So those are some policy issues that the commissions grapple with when they decide, if they decide to enact a decay or gap policy. So we have lots of other slides and information to share with you, but we are close to the end of our time, and I want to leave time for some questions. There's a booklet outside this room. If anyone could have it, they could maybe hold one up. That's got more information. Well, that's the criminal history enhancements, and then there's a little one called By the Numbers. There it is over there. And that has a lot of the information we went through today. So if you want to learn more, please take a look at that. So now, are there any questions from the audience?
Just Kelly, real quickly, I just wanted to say, I want to say thank you to Robina as well. One of the things that Alabama did was fairly remarkable in the last 5 years is that we transitioned from voluntary guidelines to presumptive guidelines for nonviolent offenses. I would say it gave us a lot of confidence that Professor Fraze, who has a great relationship with our commission chairman, had written extensively on the Blakely decision. For those lawyers in here, you actually know that was a watershed case with the U.S. Supreme Court. And in the last 4 years, in Alabama, of all places, we've reduced our prison population by 20% in just 4 years. So we're actually in the midst of the nation's largest prison reduction in just 4 years, and it actually continues to drop. And that's large part and due to groups like this that actually come together, share ideas, and a lot of the scholarship that goes on here at Robina.
Well, thank you. So what you're saying, you actually moved from, I should just go to the very last slide. So you were an advisory
Correct.
State before, so your guidelines were advisory in nature, so the judges didn't have to follow them. So what you're saying is you moved to presumptive, or not, don't use the word mandatory, but
Sure.
That's what it really means, right?
Pretty much.
So they have to follow them now, yeah. Okay.
So since we switched our mandatory minimum or increased it for drug offenses, it's kind of having a weird effect on like drug courts. So unfortunately, our prison is like the biggest drug treatment provider. And so when we take that, and a lot of people will say, like, I didn't get clean until I went to prison or jail because I had to. So is that taken into consideration? So, there's money given to outside community treatment, but if I'm in an addiction, I'm not going to voluntarily go. So sometimes, a drug court with that accountability would get me to treatment and I could get sober. So is there a way that you with your drug treatment, is it a diversion? Do they have to go to treatment, or how is that? Do you get what I'm saying?
This is
yes.
the program we were talking about. Mm-hmm. Our program is a post-conviction. We actually have a bill in right now that would actually do that as a pre-charging and provide funds for that as well. But ours is a post-conviction. If they come under those criteria, then as part of their probation, that is a term and condition of their probation. Of course, they don't have to be compliant, but we will actually pay. We have a treatment continuum that we pay for everything from residential treatment, inpatient treatment, all the way down to group outpatient type treatment. Relapse prevention, we're kind of like an insurance company as far as paying those claims. So we do, that is something that is factored into it, and that's, it is, again, since they're on community supervision, they can get revoked just like everybody else.
And from the opposite end of the spectrum, in Alabama, like most things, there are monetary problems. In the state of Alabama, there's a fight over who pays, the state or the county. And Alabama took a pretty unprecedented step 2 years ago when the state went through prison reform. The state put in a law, so we have layers on top of our guidelines. We now have special rules on top of the guidelines, as most states do. But in Alabama, if you're convicted of the lowest level felony offense, you are not allowed to go to prison or jail unless you have 3 prior felony convictions. So in Alabama, it used to be the easiest state in the nation to go to prison for. It's now probably the most difficult to go to prison or jail. If you're convicted of the lowest level felony, you have to have 3 prior convictions in order for the judge to put you in an incarceration setting. So that's forced the counties to develop drug treatment. Prior to that, when they could just send everyone to prison and say, you pay for it, state, you pay for it, the state didn't give them any money, but the state said, we're going to put a policy that prevents you from going to prison, so you, the individual counties, better come up with the programs to really effectively treat this. And that's not seamless. I'm not making it seem like they just popped up, but the actual counties, the counties across the state recognize they have to do it for actually the benefit of their citizens.
Well, I can tell you is our recidivism rates are lower than those folks that aren't in the state-paid treatment. Our revocation rates are about 21%, whereas normally they're about 33 to 34% with others. So we feel like we're getting good bang for our buck. In fact, it's about a 4 to 1. For every $1 we spent, we're getting $4 back.
And with that, we have reached the end of our time, so please join me in thanking Bennett and Scott for coming today.